Hello everybody and welcome to today's Ask the Expert webinar, Modern Contracting. It's not all about technology. Lucy, welcome. I am delighted to have you here to present to all of our members. I will hand over to you.
Thank you so much. It's great to be here. I do feel very excited to be kind of back in the world of IACCM. I actually spent a couple of years on the board of IACCM. Gosh, it's been a little bit now. So I am delighted to be back amongst people that I know understand and live and breathe everything that I understand very well. So thank you all for joining me. Again, my name is Lucy Bassli. Excuse me. I spent the bulk of my career in-house at Microsoft. I spent about 13 years as Assistant General Counsel there, and I oversaw our procurement contracting. So all of our buy side, purchasing agreements as well as NDAs. I was the head legal support for that work, and then also really worked on creating an operationally efficient program. And then about 2.5 years ago, left Microsoft, set out on my own, and now I'm a consultant working with corporate legal departments as well as law firms on modernizing service delivery with a heavy focus, of course, on commercial transactions. Contracts are still my favorite topic. They happen to be. So with that, I do play a couple of other roles which make this particular topic very interesting. We try to kind of entice people to join and be controversial, saying it's not all about technology. Not that it's a controversial statement. I'm also an advisor to a company called Law Geeks, which is an artificial intelligence solution provider to help automate the review of contracts. And having spent so much time in-house at a technology company, it's sometimes, how can I say things like this? How can I say that it's not all about technology? Well, we all know that there is nothing always forever, and anything that says all, is immediately inaccurate. So obviously it's not all about technology, but there is so much talk about it that I thought it was important to step back and remember some of the basics, some of the other things that we can do to optimize our contracting experiences. So with that, let's jump in here. And first, I want to just set the landscape. Why is it important that I say it's not all about technology? There is so much talk about contract lifecycle management tech and solutions. In general, there's a ton of talk right now about legal tech because right now, specifically, of course, we're doing this webinar during still the pandemic, and that pandemic has forced the legal landscape as well as contracting professionals into using technology more than maybe ever before. So that to me is a bit of a positive, silver lining effect of today's pandemic and situation that we found ourselves in. Silver lining from obviously a professional perspective. There's a lot of talk of technology. I just also wanted to point out that of all of the legal tech investments that have been made in the last 2 years, and tech investments have grown exponentially, basically from about 2 years ago, whereas maybe a couple of 100 million or so, maybe I think 250 million perhaps, it leaped well over $1 billion, and now we're looking at about 3 billion has been invested and injected into legal tech, with contract lifecycle management being a very big part of that. So I wanted to set this background because we're hear so much about it that it sometimes takes over discussion around contracting. And if I had a penny for every time I hear what contract management system do I recommend, I would be a wealthy, wealthy woman right now. It seems to be the first question I get. So even if people reach out to me for best practices and general help and even more general legal operations help, because that actually was my last job in Microsoft, I headed up legal ops. First question is still, what system? We need a system. So it's definitely a lot of talk around it, and that creates a little bit of confusion, frankly, for those who don't quite know where to start, but do know that their contracts are a mess. I will say, first and foremost, it's important that we all embrace the fact that everybody's in the same shoes. Everybody has trouble keeping up with their contracts. I know I just said there's no every and all and never, and I don't like those very, big words. But at this point, I will at least say that every corporate legal department that I've spoken to has a contracting problem. I might be talking to them about legal spend management. I might be talking to them about knowledge management or strategic planning, and sure enough, doesn't fail, contracts come up as a pain point. So rest assured that we have a lot of work ahead of us, and that work is not going away anytime soon to solve our contracting problem. First, a little moment on taxonomy. CLM. I hear CLM, which is Contract Lifecycle Management, often confused for CMS, Contract Management System. No acronym is perfect. There is no way that we're all going to be using the same words across the entire industry globally, but anything I can do to help further that clarification, I will do. So first and foremost, today we're focusing on the life cycle. So contract lifecycle management, it is the function. It is the ongoing series of activity that brings a contract from start, from when somebody requested, somebody in the business, all the way through to storage, and then being able to manage that contract through its life until it expires. So it is a function. When I mentioned CLM, in the course of this conversation, we're talking about a function. We're not talking about the CMS, which is of course the underlying technology. That is the contract management system. One thing, of course, about technology, I will say, is that there are so many opportunities across this life cycle that you see on your screen for automation. Some focus on some parts, some focus on others, some try to focus on everything. So even discussing contract management systems, it is a very, very broad discussion. And we will touch a little bit more on technology at the end, even though that is not the core of our conversation today. So what is the best place to start when you are struggling with technology? Let me step back. When you're struggling with contracts, see, I did it myself. It crept up on me, and I was looking right at the word. We're trying to modernize contracting process, right? Modernization doesn't equate technology. There are so many other things that can be done. In general, though, a holistic solution does require that you look at the people, the process, and the technology. There is no doubt that is a holistic solution. People, process, technology. People, so we have to start there first. Now, to be clear and transparent, obviously these overlap with each other. There's no way that they don't overlap, but to try to approach a problem as the contracts tends to become a little bit overwhelming. Contracts are the lifeline of every business. Contracts are the way that most businesses make their money. Contracts are the way they also spend their money. And at some point, every company reaches an inflection point where they're realizing that they have got to get their contracts under control. Sometimes they start earlier, sometimes they're in very, very deep and really just are panicked, or have had a audit problem or other regulatory inquiry. The reality is there is no one best way to approach it, so I'm going to share with you my philosophy and my approach. I like to start with the people. I need to understand who's doing the work today, who's touching contracts. Are those the right people? Are those the right skill sets? What function do they play at the company? All very big, sometimes philosophical, and oftentimes unclear answers on which people are touching contracts. Then, of course, you have to look at the process. What are the actual steps that are taken by those people? What is the sequence of steps? And why? I ask that. It looks like a very small, painless word. Why? Why is the most important question to ask? Because this is, of course, where we have the greatest opportunity for change management. This is where we have the greatest opportunity to move the needle and really push on why has it always been done this way? And just because it's always been done this way, that is not an answer or a reason to not change. Obviously, process oftentimes will bleed into technology. People will confuse, how they're doing things with the technology that they're using to enable. And then, of course, tech. But anybody who's worked around project management knows that these are always the core three basics. I will say one thing that's missing here that I do think is important, and I know that our community is very broad across contracting. We do cross disciplines, as we know. IACCM focuses on contract management as a profession and as a discipline. Oftentimes, the legal department is looked at as the contract management function. There is often a lack of contracting experience in any other parts of the company outside of the legal department. And then those companies were advanced enough to create contract management positions. It's usually between legal and contract management that these experiences really come to light. Obviously, in the procurement side and the sales revenue, contracting side, there are people who grow these skills, but these aren't necessarily their core job. So it's one thing that's missing here, and I do think is important, is really understanding where is that legal role, the legal advisory role in contracting. What's interesting about contracts, unlike other areas of legal operations, and maybe you've heard there's a lot of buzz, of course, around legal ops the last few years as well. Contracting is this one area where it is a completely encompassing operation in and of itself. The people, the process, the technology, all of that is something that you have to address with contracting, being efficient, using data, managing, projects, all of these disciplines that we hear about from a legal operations perspective, they're all critical to a successful contract management function. The one thing that's missing, though, is the legal advisory work. There is a part of contracting that at some point will touch legal, regardless of how evolved your corporation may be, or your corporate legal department, how empowering they have been of their business or their contract management function. There at some point will be some escalation that needs to go to legal. That is the one thing that makes, I think, contract management unique, as opposed to some other processes that can really be handled, independently within the function where they sit. So, but I digress. Let's move on. Let's get back to how we're going to tackle the people in the process before we get to technology. Let's take one step back and go even before people. In order for people to do their jobs, they have to understand what their job is. This is where policy comes in, and I'm talking about corporate policy. Usually it's the legal department that sets this policy. Again, as I mentioned earlier, that was one thing that is interesting when we talk about contracting, is that there needs to be a close relationship with the legal department. Like it or not, they have to get along when it comes to figuring out how to solve the contract's problem, because again, contracts, they affect the whole company, whether we like it or not. So when I say policy, what do I mean? The legal department has to decide first and foremost, what has it delegated to the business? What does it want to delegate? What does it allow to delegate to the business that does not require legal review? Now, this presumes that there's a legal department at the company that you're working at. If there isn't, you can probably bypass this one from the legal department perspective, but you should still have a contracting policy. So maybe it's not about the legal department setting the policy, although that's been my experience. Whoever is overseeing contracts really needs to define the policy for even having a contract. Do you always need a contract for every transaction, whether you're on the buy side or the sale side? Are there any online contracts and terms that you can make available where people can click through? Are there purchase order terms and conditions, standard ones that can be used? Whether you're buying or selling, again, what if you get third-party paper, third-party standard purchase order terms and conditions, for example? Are those the type of transactions that require the review of somebody with contracting experience, whether legal department, or if you have a really robust contract management organization? A good policy has to be put in place, and every good policy has to very clearly define the scope. So what kind of contracts or transactions are you talking about? And those are two different things. Contracts are actually the document, and we often talk about documents. We'll say MSAs, SAOs, NDAs, SaaS agreements, or we start listing off agreements. Those are types of agreements. Step back and think about the types of transactions. Is it a purchase? Is it a purchase of a service? Is it a purchase of a piece of hardware? Again, if you're on the revenue side, what is it that you're selling? Sometimes this helps become even more precise if you're really clear about the transaction type that you're trying to cover in your policy. So a good policy defines the scope. What is your policy addressing? That's first and foremost. It is clear, it is concise. Let's not write the way that sometimes we contract types used to be accused of writing, because I know now you're all into plain language drafting, you're all into simple drafting, I hope, but very clear, very concise policy, especially if you expect this to be read broadly across the whole company, across various skill sets. And most importantly, is to make sure that this policy is operational. Now, what do I mean by that? It's very easy to create a rule. I mean, that's what a policy is. And I'll speak from personal experience. There was a policy that I adopted earlier in my career that somebody else had written, that said, the business owner is required to, fill in the blank what that requirement is. Okay, even the definition of business owner, I realized, was subject to debate. I didn't know that at first, but I learned quickly. What is the business owner? Be very clear. Are you talking about the budget owner? Are you talking about the signer? Are you talking about the decision maker on that? It has to be operational in that anybody can pick it up and knows how to function within the context of the policy. Because again, the policy sets the rule, but making it operational means people know how to live in this policy. Same thing with oftentimes policies will talk about authority, right? Approving contracts. And I just mentioned, are they a contract reviewer? Are they a contract approver? There are all these different roles that if those are part of your policy, be very clear that people in the company understand. Are they one of those people? Is there a list of people that they need to go to? Where are all those things that make the policy actionable? So ask yourself with every part that you write, is this actionable? I hate to say this, pick the worst common denominator. Pick some of the folks that, just really don't get contracts and maybe are a bit frustrated about the contracting process, or you're frustrated in dealing with them. Would they know what to do with this policy? Now, the policy does not have to be the operating manual. These are not desktop procedures. It's not an operating guide. These are not, the guidelines for contract negotiation. So it doesn't have to be that specific at all, but think within the context of your company. Do the terms you use make sense? Do the references you make to people's specific roles make sense? If you talk about signature authority, by the way, one of the first policies that I see corporations, kind of find themselves having to implement because everybody's signing contracts, or they expect the attorneys to sign all the contracts, or everything has to go to the CFO, or whatever kind of extremes maybe you found yourself in. Oftentimes, one of the first policies is actually a signature policy. Well, that is the best and first place to test whether or not you are working on an operational policy, because saying that certain transactions of a certain level need to be signed by a particular person, is that person always available? How are they going to be able to sign? Is it digitally available on their phone? Do they expect to be signing contracts 7 days a week? Those are all questions that pop up immediately. Or if you've made reference to a title, maybe you say director level. Well, does director mean the same thing across the whole company? Are you sure that a director level actually has the type of experience and status within the company to make really critical decisions? Those are the kind of things that pop up when I'm thinking operational policies. So first step, before we get into the who's doing and how they're doing contracts, is what are your roles at the company for doing contracts? All right, now we're going to jump into people a little bit deeper. Again, we're going to keep hearing the themes: people, process, and then tools. So let's start with people. Skill sets matter, not titles. Yes, I just mentioned titles. That was for the purpose of authority and signature approval, maybe signature in general of contracts. But let's step back and really think more generally around contracts. What experiences do you need? Who is reviewing the contract? Who has the right to edit? Who has the right to make decisions of what terms you use? Who is actually doing the negotiation? Who's doing the drafting? Who's doing the editing of these contracts? This is where very quickly it's clear that experience is necessary, right? There are also different types of background that are super helpful when it comes to contract negotiations. I mentioned procurement earlier. Oftentimes, procurement professionals become contract negotiators because so much of what they do is grounded in that document, in that contract itself. So helpful backgrounds are important to understand, and titles might be a little bit misleading. So to be able to look at the different people that are involved in your contracting overall process is very important to try to understand, are those the right people that you're leveraging? And perhaps you need to leverage people differently. Perhaps this is the time, as you start thinking about empowering others around the company, teaching others, think about those kind of backgrounds and experiences that they have, regardless of where they sit in the company, regardless of their title. Maybe they don't have contract manager in their title, but their skill sets are what's applicable. So this is where I always want people to start thinking outside the box, not getting so caught up in titles. I will say this probably is most critical for those of you who are legal professionals on this call, those of you who are perhaps inside of corporate legal departments, attorneys, that we tend to get a little bit focused on the title. We tend to get very comfortable and confident in the work that the attorneys do, simply by virtue of their title. And I think that that's just not optimal. And what we've learned is this results in the legal department taking on a lot of work that probably is maybe not the best use of their time. It also kind of closes the doors for others to grow and evolve their own careers outside of the legal department, because there is this presumption that without the attorney title, you shouldn't be in contracts, in the contracting business. And I just don't think that's accurate. So if anything, I can really leave you with is to focus on these skills, to focus on people's experiences and bring them into the contracting life cycle. And there's a lot of ways to do that, and we'll get to that in a minute when we talk about process. Now, I'm going to ask, I put a question, is it time to consider outsourcing? So I want to be very sensitive to those of you on the phone whose core job is contract negotiation, contract editing, contract review, contract administration even, which again is a bit of a different word, right? Contract management is very broad, but administration implies certainly the handling of the contracts, maybe not necessarily the negotiation, or maybe administration implies the post-signature administration of the actual obligations, in the document itself. I ask at the time to consider outsourcing because, again, trying to be sensitive that outsourcing presumes that somehow, people's jobs are at stake. I'm not going to pretend there isn't some small reality to that. It really all depends on how the company you're part of has structured the different, people that are touching contracts. But if you break down the steps and you start considering outsourcing, there are aspects that can be outsourced. What I'm not suggesting here is an entire lift and shift of your contract management function. That might be the right solution for some companies. It will very much depend, again, on who you have in the company who's working on contracts. If you only have a handful of lawyers and there are no other contracting experts, are those lawyers spending time doing NDA negotiations? They shouldn't be. They really just shouldn't be. 1% of all NDAs that are executed probably need legal support, need the support of expensive attorney resources. And that is my favorite example because on the one hand, it's extreme, but on the other hand, it still exists out there. And that's just not good use of attorney time. Yes, obviously, this is my opinion. Yes, this is coming to you from me. But I've had enough experience to see that, no, I'm going to go ahead and be I'm going to be pretty frisky here and say, no attorney in-house wants to spend time doing NDAs. That's pretty much what I have seen and everybody I've talked to. There is the occasional NDA that is super complex and really is the basis of a bet the company kind of a discussion. Fine, there's always exceptions to every rule, but I would say that it is critical to really think about the who's doing the contracts. And if you don't have the right who in place, and I'm not talking because you don't have enough skilled people, you probably do have people with high enough skills to do these contracts, but are these people over-skilled? That's the flip side of the coin that we just discussed. We talked about, giving people opportunity to rise into contract management positions and grow. I'm now looking at the other end of the spectrum where you have very expensive resources, highly skilled, that are spending time doing repeatable, recurring work that really just really shouldn't be on their plate. It's not the best use of corporate resources. So break down the steps. If it's not NDAs, which are in general, the whole thing probably is very, very ripe for outsourcing to a combination of technology and humans. And I will just say that out there, having seen enough of what's evolved over the last several years, there are fantastic solutions for that. But if you're talking about other more complex contracts, break down the steps. Is there an aspect of it that can be outsourced? Earlier, I showed you my view of the contracting life cycle, right? The whole life cycle from the initial creation and request for a contract, even before you create it, all the way through to post-execution management. Certainly, there are steps in there that perhaps are highly administrative. I know there are many of you who probably spend time, and I don't think you'd like spending time on this, managing the signature process. Even if you are using electronic signature, you're probably spending time on that. break down those steps. We'll talk more in a minute about process, but break down those steps and see if you have people like you who should not be spending time managing that process. So is there an outsourceable function that can be, really identified and handed off to somebody outside the company that can do it for hopefully cheaper than the fully burdened cost of the people that are doing it today, and hopefully bring in some efficiencies. But setting up clear parameters is critical when you outsource. There is an entire methodology to outsourcing effectively. I don't suggest you embark on it on your own if you're considering it, because it takes a lot of work. Outsourcing, you can't just lob something over, but it takes a lot of work. So if it's time to consider outsourcing, if you think right now it's probably time, you're probably a little overdue, let's just say. If you're just starting to think about it, fantastic. Think about the people. Are they using the best skill sets, right? Is your company using the best skill sets to do contracts? More importantly, are the people that you have in contracts optimized? Are they the right people to be touching contracts? Now, we got into process a little bit already, which, like I said, there is so much overlap. I'm going to dive in deep into templates and playbooks, but before we do that, as I mentioned just now in the context of outsourcing, disaggregating the process is key. We've all heard about the unbundling of legal services, the disaggregating of legal work, what's happened for electronic discovery. Those of you who are familiar with a little bit with litigation, what happened there over the course of the last 2 decades is now happening with contracts. Companies are, of course, outsourcing pieces of their contracting work, whether they're outsourcing an entire life cycle of a particular contract type, or they're outsourcing specific tasks related to a variety of different contracts. There's no one right answer, but what it's forcing, as any outsourcing activity will force you to do, it's forcing people to really streamline their process. It is forcing people to step back and figure out if they have the best process. You should never outsource a process you don't understand. Again, I did it again. I said never, and I try not to use these big words, but I'm telling you, trust me, you cannot outsource what you do not understand. If you do outsource a process that you don't understand yourself, you are locked in with that service provider almost forever. It is very hard to take back in work from an outsourced arrangement that the internal team doesn't know how to handle on their own. So first, you have got to optimize your process. I would say it is very good use of time and money, if you don't have this resource internally in your company, to map your current state and map your future state. We'll dive into templates and playbooks in a minute. I know I'm speaking to a topic that's not directly on this slide, but if I could possibly help drive this point home, I will feel accomplished on this bright Monday morning here in Seattle, where I'm sitting. I spent time with my team when I was in-house at Microsoft. We spent a full week locked away in a conference room with 6 Sigma experts. And these 6 Sigma experts walked us through every step of our contract review process. Now, this was just my team. This was the legal team, a team of paralegals and lawyers on my team who, were accountable for reviewing contracts. So we were actually just talking about even maybe one part of the chevrons of that whole CLN cycle. And I'm going to just go ahead and scroll back to it because I do think it is, worth the time to look in this a little bit deeper. We were talking about the negotiate chevron, and that alone, we spent a solid week, and I mean 9 in the morning till 5 p.m. walking through our process. Because even in negotiate, we know it comes in to us in some way, probably email. Then we spend time looking for related relevant information. We're looking for past contracts, perhaps related contracts. We're looking for emails. Then we actually get into the negotiation, the editing, the redlining, the reviewing, sending back and forth, the internal escalations potentially. I mean, I'm just throwing out these concepts, but these are all part of this negotiate chevron. Maybe a little bit into approve if we were the ones that were kind of helping route for approvals on behalf of the business owner of that contract. What my point is that, as you can see, from request all the way through to manage, it is a complex life cycle. This does not do justice when you are looking at these few words and these couple of bullets underneath. It doesn't do justice to the complexity of contract lifecycle management. I'm sure I'm preaching to those of you who understand this. You are contracting experts, or you are trying to become one, or you have been forced into this and not an expert, but certainly trying to do it better. I implore you to spend the time to understand this process, this whole life cycle. How this flows will shine a huge light immediately on changes you can make that, again, do not require technology, changes that are process related, and you can change in little bits. You can make little tweaks along the way of that life cycle that will help things become more efficient and effective. I think if we all are very honest with ourselves, the business cares about speed more than probably just about anything. I think the C-suite cares about compliance. They want to make sure that these contracts are done in the most compliant way. But I think at the end of the day, the business that is driving the need for the contract, they really care about speed. And speed's hard because speed goes against our ability to do a very, very thorough job. So there's a lot here that goes back to policy, which is also a written form of your risk tolerance, basically. But that helps define, of course, the process, your policies and your approach to risk. I do also want to pause quickly and just remind everybody we do have a chat feature, and please, by all means, throw some questions into the chat box. That is a part of the webinar window you should have hopefully in front of you. Also, I will reserve time at the end, at least 15, 20 minutes, hopefully, to have some Q&A. I would love to make this an interactive conversation as soon as I get through the core content, and then also hopefully we'll let you all go a little bit early if that works best for you. But let's jump into templates and playbooks. I just mentioned risk tolerance. This is the first time I brought up risk half an hour into this, which is shocking because everything about contracts is about risk. It's mitigating risk. It's being risk tolerant. Every contract is a question of what is your risk tolerance. That is the I guess, philosophical question that we ask ourselves, and the umbrella under which we negotiate every single contract is what is our risk tolerance. So let's start with templates. Why are templates and playbooks even connected to process? Obviously, the better your templates, the faster your process will be, no doubt. The better your playbooks, the faster people will be able to use your templates and get through the process. The more time you spend on your templates and the playbooks, the more you have tested your philosophical approach to risk, the more you have questioned yourselves, and I'm saying you holistically, your company, your department, you've tested yourselves on your comfort with taking certain risks, and you've forced it to be written down. That exercise alone is extremely valuable. So much of what we do in contract negotiation is anecdotal. So much of what we do is personal to that negotiator. We all know that if we pick up a contract that somebody else negotiated, we immediately see 10 things we would have done differently. That's not a great experience. It's not a great experience for the person who just spent months killing themselves negotiating it. It's not a great experience for the business, who probably feels like, what? You wouldn't have made me do that? Or what? You would have made me do that? Whatever that reaction is, that lack of predictability in contracts, it's a killer for the business. The business hates not knowing how long a contract will take. They hate not knowing why some contracts end up in a different place than others. Place meaning position, why we allowed something in one contract, we don't allow it in another. It's a very frustrating experience for the business. So templates, the fewer, the better. I say this for a lot of reasons. Once we've kind of gone through the people aspect and we've made a pretty good decision about who should be touching contracts, that really helps think about what is a template and who's it for, right? That's kind of an important question. Contract templates used by just the legal team, for example, or by the experienced contract negotiators. And you know who you are out there, or we know which companies have them. Big companies especially have really big, deeply experienced contract management professionals. Well, those templates, those can be robust, they can be thick, they can be heavy because we've got experts touching them. If those templates are now to be handed off to the business to be able to hopefully handle on their own potentially, or handle big parts of them on their own. The template should be written with that in mind. Ultimately, the template should be written in the most simple possible way, because whoever you're negotiating with on the other side, whoever's negotiating it on behalf of you, it really needs to be as simple in terms of the language as possible. So simple language can still be contained in a complex transactional document. But the fewer templates you have, the better, because every template then requires nurturing. If you create a template that is outdated within a few months, there is no point to it being a template. If you created a template that still requires you to dig up other samples to compare, or other samples that you can use in that, sample language you need to put in that template, it may not be a great template. But think about it as a building block. Try to strip down the template to the most recurring, constant, obvious set of provisions that appear in the most number of contracts that you have experience with. That is your beginning building block. And think about it as building blocks. Think about the template as something you can then add other pieces on. Clause libraries are perfect for that, for thinking about building blocks, thinking about clauses as individual chunks of language that can be placed into broader set of terms, into a bigger document. I say they're great, but be careful. The reason I say that is it's very hard to over-index on the clauses. It's very, it's very easy to over-index. It's very hard to then manage them. A good contract can have, well, good is probably not the right word, but a commonly used contract can have anywhere easily, a couple of dozen clauses, let's say 20 clauses. A clause by any other name, though, may not be a clause. You can have a 5-paragraph clause, you can have a 3-sentence clause. So it gets a little difficult to manage very quickly if you get overexcited about the clauses. Like I say with templates in general, the fewer the better. Start with the basics. Start maybe with definitions. Think of definitions as things that you want to appear the exact same way, despite the template they get plopped into or land in by accident sometimes. Think about some of the things maybe that are at the end of the contract, some of those generic clauses. I don't want to say force majeure anymore because, wow, we have all spent some time on force majeure the last few months. But maybe you want to look at the, there's usually a clause that says, oh, this contract can be executed in parts. Okay, if we only said it that simply, that would be great. Sometimes it's more complex than that, but think about your kind of more generic recurring clauses first. I would say if you're going to start on the other end of the spectrum, which is indemnification or limits of liabilities or IP ownership, some of the ones, well, not some of the ones, the ones that we know are the most negotiated terms, thanks to the IACCM study that comes out every couple of years, but we also know by experience. That's always where we end up negotiating. If you want to start with those, be very, very clear of which type of transaction or contract type, whatever works in your, in your company, that term applies to. So if you're thinking about indemnity, is this always for the buy side contracts? Are these always for procurement? If yes, are these for hardware procurement? Are these for service procurement? And you start creating for yourself some pretty obvious decision trees. This is all work you're going to have to do anyway. It's just easier to do it on a smaller, finite scale than it will be when you say, we're going to create a cross library for all our templates. Well, first, how many templates do you have? And then how many clauses are in those templates? And I would say that it is can be overwhelming if you just start to extract clauses from existing sample agreements. So first, do your templates, create maybe 5. Just pick a handful and no more to start with. And then from those templates, pick maybe 10 clauses and a combination so that you are very clear on the clauses of which templates they come from and which templates they apply to. So a lot of work goes into this. It is not as simple as, again, a few bullets on the slide, but it is extremely valuable exercise. And the business will be very, very grateful. The less time experts can spend putting together contracts, the faster it gets to the business. Also, when you have a good template, you should be able to hand it to the business to send to the other side. At least there, remove yourself from that involvement, right? That is that first phase in the chevron where you're putting together the document to send to the other side. If you have a standalone template that you can now empower the business to send without ever having to contact you, assuming you are the contract holder and protector, that's where templates become extra useful, empowering the business, and they're thrilled to have it. So playbooks are next. Oh my goodness, I seem to have a virus and threat situation. Where was that when the pandemic hit? I digress. Apologies for that. Let's move to playbooks. So once we have templates, we have to tell people how to use them. And it doesn't matter if it's internally to your department, to your team of experts, lawyers, contract managers, paraprofessionals of whatever variety, even within your own department, even within your own team, even if you're just 3 people's worth of a team, 3 people big, you have to write down how these templates are used, even at the highest level. So know the audience for that template that you want to hand off. That's your playbook. Your playbook is who is going to be using this template and what do I want them to know about this template. It can be very generic, it can be very philosophical commentary, but put something together. Don't make it too long. Nobody wants to read a novel about the contracts. Believe me, the contract's hard enough to read. Do not make a playbook harder than the contract to understand. I've seen those. Don't do it. It's not a good experience for anybody. Now, when you think about a playbook, there's kind of two types I've seen, and I've seen hybrids, and I think everybody needs some form of a hybrid. One is, again, very philosophical about the how it's to be used, and then actually not so philosophical, but also tactical on where do you get the template, when you send it, what do you need to do? Do you need to send CC somebody in an email? Do you need to use a particular system? Do you need to log something in? Right? That is the how that the playbook does when it's very tactical. It's now moved past philosophical approaches to the documents, and it's now getting into the tactical. But something that playbooks get confused with also is what I would prefer to call a negotiation guide. It can be a negotiation guide for your template, which is usually a part of this playbook. You've gone tactical, and now you get into the substantive aspects of the playbook and how do you actually play with the terms in your own template. But those are a little bit different, and I would suggest a hybrid. Again, depends on your audience. All of this is going to be very flexible depending on your audience, and it has to work for you, personalized, customized for your company and your department. But now let's move to negotiation guides that are for third-party contracts. These are very hard. These tend to be much more philosophical. They tend to do more storytelling, and I'll tell you why I actually recommend that. Again, not to use a lot of words. Please don't use a lot of words. But what is very hard to do is when you create a negotiation guide for third-party contracts that is full of your favorite language to paste in. So you're trying to negotiate a third-party template, and what we're saying is remove the entire indemnity provision and plug in ours. That simply will not work. It will come back redlined like a disaster, or worse, they will just remove yours and put theirs back in. So do not create a negotiation guide for third-party templates that is all based on your favorite terms, because there's a reason why they didn't accept your template to begin with. We're all pushing for our own templates, and we're all on opposite sides of each other. So you see the dilemma we've created for ourselves as a community. And then finally, a good playbook has to have escalation parameters. What needs to go up for further review? How high, to whom? Remember what I said about policy and being very operationally minded, right? So make sure your escalation parameters in this guide make sense, and people aren't scratching their head, well, who's a director? I don't know, how do I figure that out? You don't want that experience either. Again, the more scoped and narrow you can be, one playbook for a template is a great place to start. You cannot conquer all of this at once. So start with something. And then I promise to leave some time, so I will give just 2 minutes on tools, because I said it's not all about technology, but I do want to make sure that I just provide some best practices. I am not here to answer your question of which system I recommend, because I'll give a lawyerly answer and say it depends. So I don't have any necessary recommendations for contract lifecycle management systems. Those are really, really complicated. They can be very robust, they can be very broad. And I would say first and foremost, please be clear on the problem you're trying to solve. What is your biggest pain point along those chevrons? Start there. Is it the signature? Is it finding contracts? I say that because that's probably one of the biggest problems every company has. is simply finding contracts. Or do you want to, again, have a really robust clause library so you can find information very quickly because that's what takes you a long time. So review that whole life cycle for the functions that you want to automate and really focus on what is that piece of the life cycle that is your biggest problem point. Where is that pain point? And that's what you want to attack. Then when you get into looking at different solutions, there's lots of exciting features, lots of bells and whistles, lots of good shiny things. Prioritize your features. It is very easy to get excited over the very big buffet of options presented to you. Prioritize what's the most important and stick with it. Do not waver from it because solutions invest differently their engineering resources at different points throughout that life cycle. And some are really great at intake and workflow management. Some are fantastic at a robust search. Very, very different feature sets. Think about what's most important to you and stick with it as you go through your selection process. Make sure you secure support from your IT department. It's hard to get IT's attention for contract. It is very hard for the legal department to get IT's attention, especially if you are in a technology company. They're focused on building technology things that they want to sell and make money from. If you're in a company that is not a technology company, those IT departments are there to support the minimal basic operations of that company so that we can do whatever they do and not be bogged down with the new Windows server problem. Very, very hard to get domain experienced IT support. Secure it though in advance because you'll need to think about integrations and you will want to phase in those integrations over time. Again, just like with features, prioritize your integration plan. It doesn't have to go big bang from the very beginning where your contract lifecycle management system plugs in seamlessly with your AP system or with your HR system or your sales revenue generating. I mean, there's a lot of complexity here, so phase them in and think about prioritizing. From the very beginning, identify champions who are going to go along on this journey with you. Not just stakeholders. Stakeholders are often people who are impacted because you are forcing a change on them. You're forcing, a difference in how they used to do things. Those are very important to know who your stakeholders are, but identify champions who's going to be right there with you or even ahead of you, paving the way for the changes that you are going to be implementing with the technology, which always will have process changes and might have some significant or sensitive people impacts. And then finally, please be pragmatic. In case you haven't picked up on my philosophy here on technology, there is no magic button. There is no magical solution that's going to solve all your contracting problems. There are some really, really great systems, but be pragmatic about your expectations. I would also add to really consider the feeling you have from engaging with that technology provider from the beginning, from the very first demo all the way through the selection process. Ask them questions around their implementation support and ask them questions about their support, their actual customer support program, their customer success program. If they don't have one, be wary. The younger the company, the more they are trying to sell something really great, they're building something really great, but they may not have that customer success built in. And that means as a customer, you've just invested a lot of time and a lot of money in a solution. And if you don't have somebody you can call, that you can trust will have your best interest in mind, it's a tough place to be. So I'm sure you all have some of your own experiences with this. I will stop on the technology. I will stop in general. I will say thank you so much for your time. I really appreciate you taking an hour, especially for those of you who are seeing this live on a Monday. I do have 2 books out there that if you think would be helpful, they're available on Amazon. The book is The Simple Guide to Legal Innovation. It is a big overview. It is a very simple read. It is very not technical about how lawyers especially can be innovative. Those of you who work with lawyers, buy them this book for the holidays. And then I have a workbook, again, for those, especially the attorneys who are trying to be a little bit more modern. So with that, I will stop and we will see if there are any questions.
Thank you, Lucy. That was wonderful. The questions are already streaming in, so I know that everybody was very intrigued. We have our first one here from Rod. Our Our buy and sell side contracts are managed separate from, but in collaboration with legal. We are under finance. Legal is looking at more insourcing due to the cost of external counsel and the ability to grow legal staff internally at a much lower cost. Do you see much of this?
That is a very timely question. Yes, I'm seeing it. It makes me a little concerned when I hear, they're thinking of insourcing because of the cost of law firms or of external counsel. Yes, that's a problem. Law firms should not be spending law firms should not be spending the money of their clients of doing recurring, ongoing contract work. Doesn't mean it's an easy work. It doesn't mean that it is, simple at all. But the law firm model really is not optimal, well, for a lot of things, but that's another topic. It is not optimal for contract review, for ongoing contract negotiation support. That needs to be handled differently. Law firms need to learn from the alternative legal service providers. I actually have a very close relationship with a law firm called Denton's, which is the world's biggest law firm, where we are exactly exploring this problem for corporate legal teams, and how can a law firm provide a different type of service? Because insourcing is hard. They're going to just need to get more bodies to do more contracts. Again, everybody's going to do things their own way. So unless you think of it as a holistic problem to solve in a process flow, where you have external support that flows into a process methodically, it's very hard to optimize by simply bringing it in-house. You save some money, but I just don't think it creates a better experience for the business. But those are the legal teams that they need help thinking how to do things a little bit differently, how to do things better. I'm not plugging my book, that's why I wrote the book. It's legal teams that are working with law firms in a very traditional way. Contracts is the first thing that needs to be modernized. And I have very strong thoughts on that. So yes, I'm seeing it a lot. I do hope the legal teams that are insourcing are rethinking at least how they do things themselves. At least they're thinking about templates, playbooks, right? Automation, or else I'm just afraid it's not going to make things better, even though it might help the bottom line, at first, until volume continues to grow and they're back to, again, being completely overwhelmed.
Thank you, Lucy. Thank you. We will get straight into the rest. We have one here from Marie Antoinette. How can you best invite legal practitioners to take a user-centric approach and operational approach?
Oh gosh, one lawyer at a time. So I'm a practicing attorney. I'm one of the weird ones. I love process, I love data, I love efficiency, I love technology, despite my topic for today. It's hard. It's a hard journey. Sadly, oftentimes lawyers listen when other lawyers talk to them and say, hey, I've been there. Hey, I've done it. It's okay to let go. It's okay to think about data and process. And by the way, I didn't even spend any time on data in our talk. That's literally, we could do a whole hour on just data and contracts. You have to bring them in by showing what's in it for them. And you have to bring them in by showing them that you have risk on the top of your mind. If they think you're approaching it purely from a process and efficiencies perspective, yes, most in-house teams focus on that. Law firms don't, because remember, if they bill by the hour, efficiency is not interesting to them. In-house teams, efficiency is very, very interesting to them, but they see it as an immediate contradiction with risk and risk tolerance. So come at it from the perspective that you know that risk is very concerning to them and that you want to approach it with them, right, with risk tolerance on your mind and risk thresholds, and that efficiency is the obvious natural beneficiary. Maybe just think about switching your lead-in topic.
Thank you. Our next one here is from Serene. How well could a non-legal professional handle the procurement and contract function? How has the experience been between a non-legal professional versus a legal professional? Just asking for your perspective.
Oh gosh, so much. I have so much perspective. I do worry about my answers getting a little long. This one is definitely one I could spend a long time on. Look, after you do enough contracts, you kind of learn the dance. This whole concept of what is the practice of law, where do you really need a licensed lawyer in the context of contract negotiations? And I have some strong opinions that you don't need a licensed professional for a lot of contract types. for many, many sections within a contract potentially, and for some from some transactions. Some transactions simply don't need a legal professional involved. What's happened is that somehow the world, and maybe lawyers were the cause of this, we've kind of made it so that contract equals lawyer. If I'm doing a contract, I need a lawyer. We can't do contracts without lawyers. It's not necessarily true. A lot of small companies will start without any legal department. Of course, are doing their contracts without a licensed professional, attorney. Maybe they get nervous, and maybe that's why they start spending a lot of money with outside counsel. And then they realize, well, that's too expensive. I better bring in a lawyer, and then you have your first GC inside a company. So if you think about the evolution of how in-house teams have grown and why they're now insourcing more, it's really about controlling the cost of outside counsel, who ends up doing contracts that probably don't need a lawyer for some of them to begin with. So I don't have an easy answer for you. I would say again, step back and start thinking in a very scoped way. What are some contracts or transaction types that the business can handle, or a paraprofessional that is not a legal professional can handle, and start with that and get agreement on that. To the extent you're working with legal professionals, just say, hey, can we pick something? Let's work on this together to pick something that you legal team or legal professional can stay out of, save you time, but know that it's being handled appropriately. So you kind of, you create the need for the template and the playbook coming from your side, rather than waiting for that empowerment to be handed to you. You ask for the empowerment and work with that legal professional that needs to do the empowering.
Wonderful. Moving on very quickly, we have our next question here from Juliet. When creating an agreement with affiliates language, do you recommend an international IMA approach to contracting, or do you recommend international affiliates to negotiate their own agreement due to country-specific requirements?
Okay, make me put my lawyer thinking hat on for a minute here, because this is one of those where definitions make a very big difference. I spent 13 years while I was in-house at Microsoft trying to create global master level agreements that will cover dozens, probably over 100 subsidiaries at Microsoft. It worked sometimes, and there was always a need to then create special affiliate agreements. A lot of it will depend on the structure of your corporate entity, what kind of separation is required from a revenue tax stream perspective, where you might be forced to create separate standalone contracts. First, decide for yourselves what is required and how far you can go with a global standard. Then start thinking about the other side. When are they going to rightfully request their own also separate standalone for certain subsidiaries or certain geographies? It's two very different questions, because you might be able, depending on your industry or location, create a global approach that works for all of your subsidiaries and affiliates, and you're thrilled and you've landed it, and I congratulate you. The minute that goes to one of the big four, if you're negotiating with any of the big four, accounting, consulting firms, they'll be the first to start responding to your global agreement with their specific, structure. Their structure of a partnership, will not necessarily fit. I use them as an example, again, very personal experience that I've had for years. So it's hard to answer that without considering both sides. And I would say, again, pick a few where it works. Be scoped where you can use that approach for certain types of agreements, and you'll have more luck than if you think about it very broadly.
Wonderful. We have 1 minute left. I think we may have time for one more question, if everybody doesn't mind if we take a couple of minutes extra. So we have this one here, which I think is quite interesting, from Maria. Hi Lucy, do you fear that AI, etc., will threaten our jobs and roles as CCM in the future?
No. Let me be super clear. Same answer that I give to lawyers who ask me this question, and commercial transactions attorneys especially. No, they will not threaten your job, but you absolutely must embrace them to do your job better. Or else they will be sold to somebody to convince somebody else, maybe a senior of yours or manager in your chain, that you can be replaced with a machine. You cannot, but you need to embrace it. You need to be ready for that conversation. You need to understand how you can use these solutions to become more effective and efficient yourself. I will say, if you spend the bulk of your day negotiating templatized NDAs, my favorite example, that is the first place that automation is starting, and it's doing a really good job of breaking in there. If that is what you spend your entire time on, you really need to consider upskilling and looking at other ways in which you can negotiate, either using a solution, an AI-based solution, or more importantly, other types of contracts you want to grow into and develop skills in negotiating. So I want to be very honest, and I want to give everybody a very honest answer. I don't think it is a general risk at all, but for the most repeatable type of templatized contracts, that is the first place AI will start. It continues to get smarter and smarter, as it should, and you just need to be prepared. So it's not coming after your job if you're always upskilling yourself, which we all should be. We are all professionals and need to continue to be evolving. That would probably be the best and most accurate answer for everybody. I hope that helps.
Thank you, Lucy. I am going to be really cheeky. I want to ask one more because it's come up a couple of times. Apologies for missing it the first time around, Serene. What has been your experience on excessive cross-referencing of clauses found in contracts?
Exclusive cross-referencing of clauses.
Sorry, excessive.
I'm sorry?
Excessive? Sorry, my apologies.
Okay, thank you, yes. So by cross-referencing, I'm assuming we're not just talking about a master contract and then it's kind of statement of work or it's baby contract under it, because obviously those work together that way. I'm assuming you're talking about two completely standalone contracts. I'm not a fan, as much as it sounds like a great idea when you're in that negotiation. Based on the entire hour we just spent and how difficult it is to manage our contracts, how difficult it is for most companies to even locate them, I think it creates a ton of complexity when you're trying to operationalize the contract. Again, every contract's a business document. We forget that. And they need to be operationalized. And I think cross-referencing makes it quite difficult to operationalize, if that was the context of the question, is cross-referencing between separate contracts. I just think it's hard. I think if you're able to at least use it as a link to that information where anybody who's reading the document can access it, this is assuming you're reading documents digitally, then it's a little bit easier. But if you've got paper contracts you're trying to reference, it's frankly nearly impossible, or one side will do it way better than the other side, and then it just doesn't feel good. And contracts are relationships, so you don't want to burn those.
Thank you, Lucy. That is absolutely wonderful. So I think we have stolen enough of everybody's time. So I would really like to thank you for joining us here today. I know that and I'm sure everybody else is able to take away some really solid advice that we can apply in our everyday.
Thank you so much. Thanks for having me, and reach out to me on LinkedIn or visit me on my website. I'm happy to engage in the conversation further anytime.
Thank you again. And then finally, thank you to everybody who's joined us today. Thank you for your wonderful questions. We hope that you have taken away some knowledge, some insights, some value from our discussion today. And we can't wait to see you on another Ask the Expert webinar soon. Thank you again. Goodbye.
Bye-bye.